So when somebody dies, the succession or probate process is the legal process by which decedent's assets and their bills are all paid for. There's court oversight so that it makes sure that the rightful heirs or legatees will inherit these assets. There's sometimes outside of the regular course of a succession, there's almost always some additional complexity. So, we have clients sometimes when the second parent dies that they might have numerous parcels of real estate. And, it is often the case that it is not in the best interest of let's say 3 children to co-own these pieces of property because it can create all kinds of problems. If one of them wants to do the work and they don't do it well, and the other one gets upset, that they either charged too much or didn't do the work right. The third one doesn't have any money to put up any, to do the repairs. It can really be problematic. So one of the things that we try to do is to really get clear on what the client's objectives are. And we do that through a number of different ways. So sometimes, unfortunately, people will be fighting, and we certainly will represent heirs when they, are in a litigated succession. Sometimes, most of the times, they're not fighting, which is good, but we'll try to avoid fights by trying to make sure that everybody's clear on what's going to be done and what's in the best interest to try to have these assets best managed going forward after somebody's died. The process is usually a 3-step process. There's a first step whereby we file a petition with the court to, open the succession, to probate the will if there is one. We'll typically file a death certificate. We'll file a couple of affidavits that, people basically attesting to that they knew the decedent and how many times they were married and things like that. And then ideally, we try to always get our executors, when we're representing an executor, to actually get what's called an independent administration oftentimes. And what the advantage of that is that once we get those court documents whereby the executor is appointed as an independent administrator, you can literally do anything and everything that the decedent could have done while they were alive. So we've had, one example, we had a physician client that had Parkinson's, and she was really advanced, and she was getting ready to pass away. She was trying to sell her building, and they had a buyer. They were getting ready to go to sale, and literally she died 3 days before the sale was to take place, and the kids got really nervous that they were going to lose the buyer. Well, we were able to open up that succession, have the executor appointed as an independent executor, and by doing so, we were actually able to sell that building about a week and a half after the lady died. So there's things like that that we do in that first stage. The second stage is always the most time-consuming, and that is that we have to identify, describe, and value all the assets. So when I say identify, we need to make sure we capture all the assets. And again, because we're specialists in this area, we have a bunch of processes to make sure that we're doing that. So for example, we'll look at the last few years of tax returns to see if there's any kind of 1099s or K1s that the client hasn't told us about. We'll contact, if we find some statements that are old, we'll contact those banks and those institutions to see whether or not there's still assets there. We'll oftentimes contact the Department of Revenue because they have an unclaimed property section, and we'll try to find out whether or not there's any unclaimed property that belonged to the decedent that, that they didn't know about. But we need to make sure we capture everything because, we have had some clients that forgot about some inherited property, for example. A year later, they get the tax bill and they're like, oh my gosh, why is it still coming in my deceased dad's name? And the answer is because it wasn't listed in the succession. So we got to make sure we identify everything. Then we have to describe it. So I can't just say my house or my car. We actually need the real estate descriptions or the vehicle registration. And we have a whole checklist, once again, another policy and procedure that we have that we'll send to the executor. And once they get all that data to us, then we're able to actually take the bull, by the horns and run with it. And our attorneys and our paralegals and our staff will then literally do all the work for you. It's one of the reasons, frankly, why some of our clients actually ask us to actually serve as executor, and they name us in the will, because we really do the bulk of the work that the executor is responsible for. And then we have to value it, and value can have really important tax consequences. To the extent that the value is really large, then we might have some federal estate tax issues, and if we do, There's all sorts of appraisals that we need to get of the land, of the businesses, of any kind of valuables. Even if there's a non-taxable situation, we don't always have to get appraisals done, but it can be important because the value that we list in the succession, what's called a sworn descriptive list, is the value that the heirs will inherit the assets at from a basis standpoint. So if mom and dad bought Exxon stock at $40 a share and they pass away, and it's $80 a share at the time of death, the kids will actually inherit that Exxon stock with a stepped-up basis. So even when we don't have a federal estate tax situation when somebody dies, it's still really important to establish those values for income tax reporting purposes. And then finally, the last stage is that we actually will close the succession by doing a petition for possession, and then the judge will sign a judgment of possession. That's the actual legal document that will transfer the title from the decedent's name to the rightful heirs and legatees.